Ethics at the intersection of psychology and the law, and we're going to focus on mental health ethics. So if you're a lawyer, you're welcome to stay, but the focus will be more on the APA Ethics Code and mental health ethics. And I'm Lindsay Childress-Beatty. I'm the Director of Adjudication at the American Psychological Association. I'm also Deputy Director of that Ethics Office.
This is Robin Deutsch, and I'm a psychologist in Boston, primarily at the Massachusetts School of Professional Psychology. And I was on the ethics committee and chair of it in maybe 2006. So the first step obviously is to figure out what is it that I'm concerned about, what might the conflict be, and then to find the ethical principle that applies to that situation. The second step is to figure out what is it about your beliefs, your attitudes, your biases that may influence the decision that you want to make. In other words, we're all kind of looking through the lens of what we're hoping the outcome would be, the best outcome for us would be, but often that lens is filtered with our biases and our wishes. Third is consult, consult, consult. So the fourth step is to consider all of the options. So what you want to think about is what the short and the long-term consequences are to the relationship with the client, what's going to be the impact on all the parties, what are the competing and multiple interests, what are the economic consequences and implications. And that sometimes becomes one of those bias lenses through which we try to view things. And what is the best kind of risk management perspective? How can I manage this to really reduce risk? And how is it going to affect my professional reputation? Step 5 is to consider the hierarchy of principles and the impact on our personal interests of each of the potential options. Then, of course, we choose the best option. And am I comfortable with my colleagues knowing how I processed this, how I thought this through, and what my decision was? And then, of course, you review with your consultant and finally evaluate the outcome. So this is in your materials too. This is just one decision-making model that we have found to be useful. Okay, so our first vignette is It's a Small World, and we're not in Disney World. So it's still a small world. Dr. Moody, a local forensic evaluator who specializes in child custody matters, has just received a call from her friend, Jonathan Fears, Esquire, with the state attorney's office. Mrs. Bitters just left his office. Mrs. Bitters has 4 children with Mr. Bitters, who was just arrested for possession of child pornography. Mrs. Bitters is concerned that in addition to viewing child pornography, Mr. Bitters has molested the children. Mr. Fears needs to make a determination regarding further charges of Mr. Bitters. As one aspect of that decision, he would like to hire Dr. Moody as a consultant to evaluate the defendant, Mr. Bitters, to determine whether this allegation is true. Dr. Moody remembers meeting Mr. and Mrs. Bitters at Attorney Fears' annual Christmas party last year. The next day, Dr. Moody receives a phone call from her daughter, who's a kindergarten teacher. She recounts how the mother of one of her students came to school very upset and made a big scene. The mother told her to not let the child go home with his father because the father's a pervert and was arrested for possession of child pornography. When Dr. Moody asked her daughter the mother's name, she was dismayed to hear Mrs. Bitters. So, now begins the discussion. How should Dr. Moody proceed? And what steps? Well, how should Dr. Moody proceed? So someone want to start? Arnie?
I would have concerns about being involved then and probably refer to someone else.
Why would you have concerns about being involved?
Because my daughter is the child in question's teacher.
Because your daughter is the child in question's teacher. And where may the conflicts arise as a result of that? Someone else want to respond to that? Yes. Yes, you in the back.
My concern is they're asking me to do something with a psychologist I don't have the wherewithal to do to determine what sexual abuse of children occurred.
So that's a second concern you have, is the referral question is not one you think you can respond to because you can't determine whether sexual abuse occurred. Others? Yes. No, the mother hasn't asked you. The state attorney has asked you. Okay? Others? Yes.
In our jurisdiction, the role of validating or invalidating an allegation of is the protective service as opposed to a psychologist.
Okay, so validating is the job of the DCF or whatever it is, Child Protective Services, and not that of an evaluator. On the other hand, in many jurisdictions, CPS may support or non-support, but then a psychologist is asked to do a sexual abuse evaluation and/or to do a sexual offender evaluation, right? Yes.
There's concern about the prior relationship with the referring attorney and possibly with one of the parents if we were socializing at a holiday party the prior year.
And what about the holiday party? More information would you need to think through as Dr. Moody? So, for example, was it so nice to meet you? Shake hands, move on? Or what are the other things you're going to be thinking about yourself? Phil.
What kinds of information about the family were you given when you met the mother?
Oh, good point. What kind of information about the family were you given when you met the mother? Yes. What was your behavior at the party? Were you totally sloshed? Completely sloshed and laid out? Right? Okay, yeah.
You was it like AFCC hospitality room?
Yeah, exactly. AFCC hospitality, yes.
Excellent.
Yes. Yes, very good point.
And one other factor that's not in the vignette is, but we don't know if this is a rural environment or an environment where there's lots of alternative choices, and whether these kinds of multiple relationships occur a lot because you can't help it, you're in a small town, versus areas where you can kind of steer clear.
I was going to get up the ethics.
Yeah, that's good.
All these are valid sort of intellectual approaches, but isn't the basic rule of thumb that if there can be the perception of conflict or new relationship or prior relationship or inappropriate behavior, that will confuse the process later on, that should be avoided?
I think this is a great time to talk about the ethics code. The APA ethics code actually has a test, and I'll read it to you, and then we'll talk about it, because embedded in the test is the idea of apparent and actual conflicts, but those words aren't used in the test. So I'll read it to you while you're pulling it up. So it says, basically this is the same test that's in the multiple relationship rule and in the conflict of interest rule. And it basically says, if the multiple relationship could reasonably be expected to impair the psychologist's objectivity, competence, or effectiveness in performing his or her functions, or otherwise risk exploitation or harm. Now, the first one, I think, when you talk about effectiveness in a forensic setting, that's where you get into that apparent, is it going to affect your effectiveness because people are going to think you're biased, versus the objectivity where it's more of you have an actual conflict. So it's kind of embedded in the middle of that. And what do you all think? about the first scenario versus the second scenario, the social versus the kindergarten teacher aspect. Any thoughts on how that could affect objectivity, competence, or effectiveness?
Yes.
Well, I think the defend act.
I'm also thinking of three other parts of that, actually. One is if the father understood that she found out, because you didn't disclose, that she was your daughter, I would be worried about some safety issues. Number two, someone mentioned yesterday, the teacher may be used as a collateral. And then number three is the question of where are the duties of confidentiality? The daughter can talk about the child to her mother, but the mother there has to be a Chinese wall, and as you were talking about how difficult that would be to maintain. So you think the teacher thing trumps? How many people agree with that? How many people think the Christmas party trumps? It depends on what happens. It all depends.
Yeah, right.
The only other ethical principle that I think... Thank you. The only other thing I think that you may want to be thinking about is, and this would just be a first step before you find out all these other conflicts going on, is competence, that you really would be competent to do this kind of thing. And it's not just because he's your friend, attorney fears, right? But more importantly, we're 3.05 and 3.06, multiple relationships in conflict of interest. And what really you also have to think about in all of these dilemmas is the actual potential conflict versus apparent conflict, right?
And I had two thoughts on that. One is that I think when you look at this, you end up also thinking about this from a risk management perspective. And when you start to think of what possibly could happen down the road, you start to think that there's problems you haven't even thought of that could come up. Is this really worth getting into from a risk leaving the ethics aside from a risk management perspective? The other thing, when you were talking about competence, there is a way to do an evaluation and you're not going to be proving whether it's true or not.
Right.
But, obviously there is a type of evaluation that can be done. Are you competent to do that type of evaluation?
Exactly. Yeah.
What's the probability that it's a...
Excellent point. Excellent point.
And I think about most of you are saying that the kindergarten teacher is that point.
But your behavior at the party might also be.
Right.
Could be.
Could be. Very good point. We're going to go on to Dr. Heyer.
Okay, so Dr. Heyer has a bunch of different pieces of testimony, and what we're going to do is I'll set it up for you and I'll read you the first section. We'll talk about it. We'll go on to the next part of his testimony. Okay, so Dr. Heyer's testimony. Mrs. Johnson moved out of the suburban family home at separation and into an apartment in the city, leaving the young daughter with the father for what she thought would be a temporary basis. The court-appointed custody evaluator had recommended that Mrs. Johnson have physical custody and Mr. Johnson have liberal parenting time. Dr. Heyer, a forensic psychologist, is hired by an attorney, Mr. Money, to review the work of the court-appointed custody evaluator. Below are excerpts from Dr. Heyer's testimony on direct examination. Dr. Heyer, you were given a set of emails from Mrs. Johnson to Mr. Johnson, were you not? Dr. Heyer, yes, I was. Attorney Money, and did you read these emails as part of your review? Dr. Heyer, yes, I did. Attorney Money, and what did you identify as issues regarding those emails? Dr. Heyer, well, these emails fit within the findings that Mrs. Johnson has difficulties related to anger. They also show that she is narcissistic and has difficulty looking past her own needs. Her tone throughout the emails was disdainful. Mrs. Johnson's focus was on making the time spent with her daughter equal between the parties and rehashing past issues in the marriage rather than the needs of her daughter. In the 5 emails, there were 7 instances where Mrs. Johnson completely ignored a reasonable suggestion of Mr. Johnson regarding their daughter's distress when visiting with her in the city, and only 1 suggestion by Mrs. Johnson related to ameliorating her daughter's distress. Mr. Johnson continued throughout the emails to try to get Mrs. Johnson to acknowledge the distress the little girl feels when she's in the new apartment in the city. You've got to remember that this is a mother who moved away and left her young child. So what are the ethical issues related to Dr. Heyer's testimony? Any initial reactions to it? Mm-hmm.
I can't quite remember what you said. Who provided the email?
Excellent point. The way it's written, it appears to have been provided by the attorney that hired Dr. Heyer. So
Attorney
one
Money.
side of the Attorney Money, provided these emails. What do you think the issue is related to that? I mean, do you have any thoughts on that?
Well, I think that the obligation of the evaluator is to look at a broad spectrum of behavior and a fair spectrum of behavior.
Mm-hmm.
And if Dr.
Higher. Hi.
Didn't do that, then he has too few data points to offer an opinion on these matters.
So you're talking about likely a subset or possibly a subset of emails that really aren't giving you the whole picture. So that's one aspect of the email.
And let's remember, Dr. Heyer is not the evaluator, but critiquing the
He's
evaluator.
critiquing the report.
Alternative hypotheses. Evaluating.
So he's using evaluative language. There's this comment at the end. I mean, what do folks think about, you've got to remember that this is a mother who moved away and left her young child. So that kind of comment. There's some problems here, right?
9.01 is the assessment.
Is the assessment. And actually, let's stop for a second. It's helpful to read it. So the first one, 9.01a, talk about any opinions, but one aspect of those opinions. So it says, any opinions in their recommendations, reports, diagnostic or evaluative statements, including forensic testimony. And then I'm going to go back so that you get the whole thread. Psychologists base the opinions on information and techniques sufficient to substantiate their findings. So you've got to be thinking about what is the basis for the statement that you're making. Now, when you talk about, let's just go to this last statement for a second. You've got to remember that this is a mother who moved away and left her young child. So there's the first aspect that this seems sort of like a gratuitous comment, and several people have said that, and it's like a barb. And so there's that aspect of it, but you're thinking there could have been a way to talk about the mother moving away that either had a scientific basis in a literature or information from the child custody, what the child custody evaluator found, that could lead you to discuss what it means, as Phil said, what it means for the mother to have moved away. Is it a positive? Is it a negative? How is that to be interpreted? But it has to be based on either the literature itself or the information that's in the report.
Such as the information in the report might have said this child felt abandoned, this child felt whatever it was, but just to make it up wholesale. Yes?
Well, the other is make a diagnostic determination that she's not a person who's never not personally done the testing.
Exactly.
That's a really interesting comment. I want to reread the statement, and I'm not disagreeing that if you were actually making statements about psychological characteristics, that would be a big problem. And 901B talks about that basically you need to have conducted an examination, or you need to have tried to do so, and then you need to limit your opinion. But let's read exactly what he said. Well, these emails fit within the findings that Mrs. Johnson has difficulties related to anger. They also show that she is narcissistic and has difficulty looking past her own needs. So the way he's worded it, it's somewhat unclear. It sounds like at least part of his information is coming from the findings of the child custody evaluator.
Although those aren't ever findings, right?
Right.
Yeah,
right.
The findings only come from
Poor
the judge.
words.
So, right, it's the impressions
From
the summary from the custody eval.
So is this his own diagnosis, or is this coming from the evaluation? So how could that be worded in a way that it's clear to the court where this information is coming from, if it even has an adequate basis. Any thoughts on? Do you want to go? Do you want to? Okay. One other thing on that also is, we could get into a very semantic discussion about the word narcissistic, which is used by the public, versus an actual diagnosis. I have one more point on this section that I think is really important. What does everyone think about the use of the quantities of the email? This sense of 5 out of 7 and 1 out of 7. Any thoughts on that? Mm-hmm.
There may be a lot of emails that were not given provided, or it could be if this is Dad's attorney, if he kind of directing here, Dad's looking good and Mom's not.
Right.
So we don't know the denominator.
No, right. We don't know the denominator, but also emails can be altered as well.
And
Yeah.
can this be a hand-picked subset by the attorney? Yeah. And then Phil. I think we have been looking at it as, do they violate? And we have been saying that this is incredibly close to the line, but depending upon what he was trying to say, you could make, we tried to pick something that was really, clearly from a risk management perspective, you would not want to be anywhere near this. And I think one of our messages is taking due care to speak well, so that it's understood what your scientific basis was, or what the basis was for your comments. And it's not clear. It's not really clear. I do think that you could read this, that he's saying the child custody evaluator had the following impressions of the mom. This, and this. But he's not saying that clearly enough.
So in the next section, we'll go through some other possibilities.
So we're not looking at best practices, and there are some things that there are disagreements about. How far, for example, someone reviewing a child custody evaluator, things like that.
Phil?
So one last, something that's problematic becomes really problematic, in my opinion.
And I would also add that I think that the more you use just observational language, like the email said the following, which was completely focused on her needs and not on the child's needs. On the other hand, we don't know what preceded that email.
Or what came afterwards. Someone made the point that she may have continued the conversation by text at the soccer field, and nobody gets to see what she then says back when she is worried about the child and has thought through what has been said in the emails, that sort of thing. Also, okay, one more thought, and then we're going to go on to the next thing, which is someone made a great point yesterday, is if you're getting the child custody evaluator's complete file, hopefully you have gotten emails from one side, and then the other side has been able to see what was given or knows what was given, and also has been able to submit. So you at least have a little bit more assurance that you've got a wider range of email, rather than just taking it from the one side's, what the one attorney wants to give you. Last thought, and then we're going to move on.
Your responsibility as a reviewer to make sure that you've got 100% of the dialogue. That just because it was selectively, we have to assume that it was selectively.
And you have to think about what else could be there. Mm-hmm. All right, let's go on to the next part. So the testimony continues. Attorney Money, now we've discussed the vulnerabilities of the little girl involved in this case. In your opinion, could she adapt to a sudden change in her current parenting schedule and a move to an urban environment? Dr. Heyer, we understand this to be a child who has an exceptional need for constancy and stability and has had difficulty with anxiety. And given her age, I do not understand why you would recommend an abrupt change in that parenting schedule, especially not away from the family home. We know that children of this age have difficulties with this. So let's stop there for a second. What do you think of just that aspect of it?
Right.
Right.
So everything has... Why don't you read it one more time?
I'll read it one more time.
And as Lindsay is reading it, think about how you would respond differently to the question.
How would you rewrite it to make it clearer that it's ethical. We understand we understand this to be a child who has an exceptional need for constancy and stability and has had difficulty with anxiety. And given her age, I do not understand why you would recommend an abrupt change in that parenting schedule, especially not away from the family home. We know that children of this age have difficulty with this.
Yes. And so on cross-exam, I'm going to say, well, you said based on the data. What data are you talking about?
The data that the evaluator has provided.
Including what?
Including the interview she had with the child, the test results she had, the collaborative
Right.
information that she provided.
So you lay it all out. Yes.
Carol. Yes, I think that's also important, and we want to talk a little bit about that. So now we've discussed the vulnerabilities of this little girl involved in this case. In your opinion, could she adapt to a sudden change in her current parenting schedule and a move to an urban environment?
So, I mean, it seems to me that when you have that question, you do need to have a response that says, I can't give an opinion about this.
Exactly. The first phrase is, I cannot offer an opinion about this child, but based on what has been reported about ages, da-da-da-da-da.
Right. Although,
Absent that statement, is that necessary in order to not have mental violence?
I think you could talk about this child, but only in terms of what the findings are of the child custody evaluator, and then where that might lead to a different possibility. And I also think that that really although it's embedded very much in here and it needed to be much more explicit, they're talking about how quickly the change should occur as well, which is another factor.
Give an opinion about this child. You can talk about the data from the child custody evaluation, but if I give an opinion about this child, I think that crosses the boundary.
Yeah.
Right, but you can say this child and the recommendation doesn't fit all the data, and there are alternative recommendations. That's what I'm trying to say, yeah.
Right.
Right.
And you can talk about children of this age with the kind of temperament that has been described.
Right, so you can talk about it both ways.
Even if you do that, you have to talk about aggregate data. You have to talk about it centrally.
Exactly.
You're going to record or whatever. I think it's only fair to take note of the other piece of the data, which is this 31% no.
Yeah. Exactly.
We should go on to the next part, because you're going to love the next question then. Attorney Money, Dr. Heyer, have you reached an opinion concerning the ultimate recommendation of custody in this case based on the findings? Opposing attorney, objection, beyond the scope of what she was called for. Court, overruled, you may answer the question. Dr. Heyer, yes, I have. I don't see how you come up with an opinion to move this child to a completely different environment, especially given her vulnerabilities and her mother's personality. There are lots of other solutions that would be kinder to this child. Attorney Money, so Dr. Heyer, you believe that keeping this child in her current situation is the best thing for her at this time? Dr. Heyer, I think there are better ways to allow this child contact with both of her parents. Mr. Johnson is an appropriate caretaker, primary caretaker of his daughter. So what are your reactions? What are your reactions first to the question that he's asked by the attorney? Have you reached an opinion concerning the ultimate recommendation?
It does. It does. And what is your response? I cannot answer that question. Okay. Now, when the court overrules, then Dr. Heyer went ahead and answered. Are there any problems with that?
You still set the standard, even if the judge says answer, you say, I cannot or I can't. I don't know which of those 3 children sitting here is the one we're talking about.
And we often say that you end up having to educate the court about your ethics. That happens.
So now we're talking 1.02. We're talking about conflicts between ethics and law.
Right.
Can you discuss 501c in this context? Because I feel like some folks kind of use that as their cover.
Avoidance of false or deceptive statements. Claim at degrees as credentials for health services must be a different number. What's the topic? Okay, that's 901. 901C. Well, 901C doesn't, it's interesting because it says when psychologists conduct a record review, so this is what we're talking about, or provide consultation or supervision, and an individual examination is not warranted or necessary for the opinion. Psychologists explain this and the sources of information on which they base their conclusions and recommendations. So if you think about, I mean, what could Dr. Heyer have said? Here's what he actually said. Yes, I have. So we've got that problem that the question is not worded in a way that's helpful by the attorney. Then he says, I don't see how you come up with an opinion to move this child to a completely different environment, especially given her vulnerabilities and her mother's personality. There are lots of other solutions that would be kinder to this child. So how could that be reworded so that it's clearly ethical and from a risk management perspective, you're in much better shape? Does anybody think that because he said there are lots of other solutions that would be kinder to this child, you know, can we make the argument that he's not actually saying, he's saying, I don't agree with what the evaluator found, but I'm not saying what should happen.
Right.
And you could say these child custody evaluators said that this child had these vulnerabilities, this mother had this personality, and then they made the recommendation to do this, to move to the city abruptly. And the literature shows that there are other options, and here are 3 or 4 of the other options in the literature. That you would feel more comfortable with that. Are others in the same position, thinking the same thing? And it basically, that's where 901C, an individual examination is not warranted or necessary for the opinion. And this is written very broadly, so obviously 901 is not just covering child custody, it's covering a lot of different scenarios. And I think, so where does the ethics committee start to look when they're thinking about this? And, you know, the guidelines that are out there, the standards, what are the standards of practice? What does the literature say? Are there arguments in the literature back and forth? And some of these things are much better understood than others. So there'll be that interpretation that has to go on. And that's where people sometimes can use it to drive the Mack truck through.
Big hole. Yes.
I'm sorry, I didn't hear what you said.
When are those instances that you've seen where it's not warranted or where it's not necessary, where people have been able to justify not meeting with an individual?
Well, see, I don't think they're not saying meeting or not meeting. They're just saying if you're doing a record review or doing consultation or supervision and you don't have to meet with the person, but it's not just in child custody. So I'm trying to think, can you think of an example that's not where you don't need to
meet with the person? Well, I would argue, I have a conservative view of consultation. I would argue anytime you're working with an attorney to do litigation support as an expert, anytime you're an expert witness for an attorney for one side, you never meet with the person, ever. Everyone doesn't agree with me.
Yeah, that's more of a, standards of practice.
Yeah, that's standards of practice. And you
so
meet
your
with
opinion
the
is
person?
not, well, yeah.
But why would you meet with the person?
You don't have to do, and actually it's not meeting with the person, it's an individual examination. So I think it means doing the examination yourself, whatever that might be. So it could be meeting with the person, but could also be completely redoing versus making a comment based on the records review. And that happens a lot if you think about it in forensics where you're doing the records review, but what we're talking about is inside the line versus outside the line. I also think people don't focus on the last part. You explain this and the sources of information. And that's what we've been talking a lot in this scenario. What are your sources of information? And have you adequately explained what they are, which just even from a risk management perspective needs to occur. Let's go on with the last little bit of it, and then we'll go on to the next one.
Right.
There's one little part of it.
I just wanted to refer people, if you don't have a copy of it, it's in the
This is great.
Family Court Review, Volume 49, Number 4, 2011, 723 to 736, and it is a white paper, basically, on mental health consultants and child custody evaluations, a discussion paper. We were tasked with creating guidelines, but we couldn't reach consensus to write guidelines. So instead, we wrote this paper, which has to do which lays out some of the controversies. If you're a member of AFCC, of course, you can get this online.
Okay, so this is the last little bit of this testimony, and then we'll go on to another vignette. Attorney Money. So, Dr. Heyer, you believe that keeping this child in her current situation is the best thing for her at this time? Dr. Heyer, I think there are better ways to allow this child contact with both her parents. Mr. Johnson is an appropriate primary caretaker of his daughter. So what kind of reaction do you have? What do you think about the last sentence? Mr. Johnson is an appropriate primary caretaker of his daughter.
Correct.
Mm-hmm. But he could have said it in a certain way. The child custody evaluator found that the parenting of Mr. Johnson was adequate. He's still going beyond some other issues, but any other thoughts on that? So explaining the basis, explaining the limitations of what you've done and what you've not done, being very careful in how you word it. The other thing that came up yesterday, and I think this is something you've probably all thought about as well, which is in that discussion where he's being hired or where there's witness prep for him, he should be helping the lawyer understand what he will be able to say and what he won't be able to say, so that the questions are limited so that he can answer them clearly, rather than, because this question, for example, is much broader than where he could ever go, and he's going to have to say, I can't answer that, what I can tell you is, or something to that effect. So that kind of interaction will help the psychologist be able to give ethical testimony, and talking to the attorney ahead of time about here are my limits is risk management strategy. Mm-hmm. So you're talking about a situation where there's a child custody evaluator, and then in that jurisdiction he's called by one side.
Correct.
So you're talking about the evaluator, not the consultant.
Well, I do mental health professional. In this case, it would be a parenting coordinator.
Who gets called by one side?
Who gets called by one side?
Usually, all one side would call. In Maryland, we do things conjunctively a lot.
Yeah.
In Maryland, we'll have one for Virginia.
So I missed a piece. I was unclear. What's your concern?
Well, I would just like to hear any discussion about how you all draw the line because it's not the work you did was neutral, but you are going to be coming in as a witness for a party.
Yeah.
So professional.
That's what happens to a custody evaluator. You're called by one side, but you don't get prepped by either. And you go in and you answer the questions to the best of your ability.
In Virginia, you get prepped.
Oh, well, I would say that's a problem. Well, you're not supposed to be a secondary evaluator. But all those issues are laid out in that paper that I showed you, because it's a very controversial area. And there's a whole continuum of practice. Some of us would find creep, and where you really are working outside the bounds, and other people say, sure, that's part of the role. And you've heard that at this conference. You've definitely heard this at this conference.
And, where's the line is basically you can go back to that test. Is the information and technique sufficient to substantiate their findings?
When I overstep so far.
Well, I think most judges are going to say that's how a witness would be impeached if they overstep. Yeah. Let's go on to the next scenario.
Next scenario. Yeah.
This one is called Reduce, Reuse, Recycle. Dr. Forensic was appointed to conduct a court-ordered child custody evaluation when Mr. and Mrs. Trouble divorced. The evaluation took over 25 hours and involved standard forensic methodology, including interviews, psychological testing, parent-child observations, review of documents, and collateral contacts. About 6 months later, Dr. Forensic received a subpoena from Mr. Trouble's employer. Immediately following the completion of the child custody evaluation, Mr. Trouble was terminated by his employer, who claimed his performance was unsatisfactory and that he misused his company's credit card. Mr. Trouble blamed his wife, stating she had made the allegations that resulted in the termination. Mr. Trouble filed a lawsuit against his employer, claiming he had suffered emotional distress and mental anguish. The subpoena requested that Dr. Forensic release all test data on Mr. Trouble. The subpoena also requested that Dr. Forensic appear at a deposition in 2 weeks. How should Dr. Forensic proceed?
So you would seek the court's permission.
So you would, or in the alternative of seeking the court's permission, you may seek what? A protective order. So either permission or a protective order. Okay? All right. In this case, who's the client? The court is your client. Okay. What about the testing? What was the testing done for? Custody evaluation. So would the testing for the custody evaluation, using whatever tests were chosen to be used in a time of what all stress scales call an extremely high stress situation, would that testing apply in the case of
Mr. Trouble's employer and it's basically an employment issue.
He was terminated, who claimed his performance was unsatisfactory and he misused the company's credit card. But he filed a lawsuit against him, claiming he has suffered emotional distress and mental anguish. What do you think about that? The testing. It's a different context.
And timing also.
Different timing. What else? Different question.
Now that is an interesting, and we hear that all the time, and you can set it up in certain exceptions to have it go that way.
9.04.
But if you look at 9.04, it basically says, pursuant to a client-patient release, psychologists provide test data to the client, patient, or other persons identified in the release. So in general, let's talk about it not in a forensic setting. In general, if a psychologist receives a request for test data, we're not talking about, things that would give away test security, that would be like the manuals or have stimuli that would give away the test.
That's 9.11.
Which is 9.11, that you release. And then there are some exceptions, and people sometimes use those exceptions. And neuropsychologists tend to use those exceptions. Psychologists may refrain from releasing test data to protect a client, patient, or others from substantial harm or misuse or misrepresentation of the data or the test, recognizing that in many instances release of confidential information under these circumstances is regulated by law. So basically, since 2002, the basic standard is in general, release with a client, release the test data with a client release. There's no requirement anymore that it go, like there was in the last code, that it go to another qualified professional. Now, you do have these exceptions that you can work with in an unusual case where you really are worried about the reason for the request and how it's going to be used, or you're worried about protecting your patient. So it's an interesting thing, and it's something that's been talked about ever since the code was changed, and people often use the exceptions depending upon the kind of work they're doing. But in general, it's release.
So the clause in here that could possibly apply would be misuse or misrepresentation of the data of the test, yes. So in the back. Lawyers, and is there a lawyer?
But what's so weird? So your question is, his therapy records are usually, because he's opened up that question, the question of his mental health. But the forensic records, I think, are sort of seen differently than that. Mm-hmm. Does that make any sense? Is that sort of, yeah. Yeah, you do often hear when someone brings up the issue of their mental health, then they've opened the door to the other side getting their mental health records. That's kind of what you're talking about, the general premise. Mm-hmm. Mm-hmm. Right, and a lawyer may be able to tell you that this is not a valid subpoena. There may be a way to quash the subpoena, working with the lawyer. It's more unusual. You have this added layer when you're talking about a forensic, because you are talking about the court. In most jurisdictions, the court is the client, and so you've got to work with the court on the issues. But getting an attorney to help you figure out, is this a valid subpoena, and where do we go from there? And of course, you never just ignore a subpoena. You figure out what it is you're supposed to do or not do. Yeah. Yes. Mm-hmm. Can we draw your attention to 4.05, disclosures? So A is psychologists may disclose confidential information with the appropriate consent of the organizational client, individual, or legally authorized person, etc. B, psychologists disclose confidential information without the consent of the individual only as mandated by law, or where permitted by law for a valid purpose, such as to provide needed services, obtain appropriate consultation, protect the client, patient, psychologist, or others from harm, obtain payment for services. Now, let me ask you this. In this particular case, is a subpoena considered mandated by law? No. You have to respond to a subpoena, but that's not an automatic release. Yeah. Mm-hmm. Yeah, there's only one other, which is this aspect that I think we need to bring out. Oh, it's only been 6 months. So one of the questions, looking at this vignette from a very different point of view, but when you get this subpoena, if you're the child custody evaluator, are you going to be thinking about, have you received any new information? And do you need to do anything to update your child custody evaluation? And how would you go about that aspect? So in other words, you did this custody evaluation. Immediately following it, you turned it in. Immediately following it, he's fired. And there's various allegations. And then 6 months later, you find out about it because you get the subpoena. Any of you have any thoughts about any kind of update for the child custody evaluation? I don't know why you would update a report, because both attorneys are ultimately going to know that Dad's been terminated. And you're probably going to either be seeking a protective order or quash the subpoena, one or the other. So that's all out there. And if the court wants you to update, either one of the attorneys is going to motion the court to have an update, or the attorney or the court is going to ask on its own. Exactly. When you've gone to them on the subpoena issue. Right. Okay, we're going to move on to another one. This is called the afternoon Rorschach. Some people have afternoon tea.
Others have afternoon Rorschachs. Dr. M has been appointed by the court to make custody recommendations involving 3 children, ages 3, 4.5, and 7, in a case that fortunately is one of the less contentious she's been involved in. One of the adults whom Dr. M must test, Ms. S., lives in a rural area a considerable distance from Dr. M's office. Dr. M has successfully gathered much information over the phone and plans to complete her data collection upon a single visit to Ms. S.'s home. Dr. M schedules her visit and enjoys listening to NPR on the drive out. Just a little aside. Upon her arrival, Dr. M discovers the children are present. Ms. S. is extremely apologetic, explains her daycare fell through at the last minute, too late to call Dr. M and reschedule. Dr. M says she'll come back to do the testing another day. Ms. S. insists that she need not make another trip for the testing and says it's almost nap time for the children. She says she'll place the children in the next room where they will take their naps and where she'll be able to hear them if they wake up, and that way she and Dr. M can do the testing right now. Dr. M takes the opportunity to observe Ms. S. prepare her children for their nap. After the children appear to be asleep, Dr. M asks Ms. S. a few questions and they begin the testing. Dr. M starts with the WASAR. On block design, Dr. M hears a voice from the corner say, "Can I play with those blocks when you and that lady are all done?" Ms. S. tells her 4.5-year-old to finish his nap and then Mommy will make him a snack. Dr. M and Ms. S. successfully finish the WASAR, although Dr. M notes that Ms. S. seems to be watching the room where her children are napping. Dr. M next begins to administer the Rorschach. On the inquiry to card 1, Dr. M hears a little voice in the corner say, "Look at the pretty butterfly, Mommy." The 3-year-old is awake. Dr. M completes the Rorschach and with the child sitting quietly in the corner with a glass of juice. Dr. M goes on to complete the testing and prepares a report for the court. Bummer, huh? What ethical challenges has Dr. M encountered? And what ethical challenges may she encounter as she prepares her court testimony? Non-standard administration. Distraction.
Well, presumably there was no parallel process with the father. Unless it was set up in a parallel way with the father, who also had the opportunity to give juice to his daughter.
Right, and be in a corner.
Right. And be in a corner.
The kids in the corner during nap time. Yeah.
Also observe parent-child interactions that she noted that she's got to do that too. I guess to observe the father-child.
Okay. If Dr. M came to you to review the case, what advice would you give? So how would you have set this up differently from the very beginning? So we know that Ms. S. lived in a rural area. It was like 2.5 hours away, something like that. She did most of her work on the telephone before this visit. How would you have set this up differently? Right. What would you have done if she showed up at your office with the 3 kids? What? Cancel the meeting. Yeah. So sorry. You can do the, well, she can go to the home to do the parent-child observation.
Yeah, I do too. I do an office observation and a home observation.
Yeah, so she could do 2. Fine. Any other comments, thoughts? Bad situation. She lost control. Anything else?
I think you've got it. I mean, basically 902A talks about administering. It says administer, adapt, score, interpret, or use. But here we're talking about administer. and its techniques, interviews, tests, instruments, so on and so forth, in a manner and for the purposes that are appropriate in light of the research on or evidence of the usefulness and proper applications. So whatever the literature says about a standard administration, you want to be able to say that you've done that standard administration. And I think several of you came up with some good ideas to try and manage it. And how do you make it as parallel as possible, but maybe it's never going to be 100%, and how do you add that into the interpretations? Because you could have that scenario where one person lives a lot further away or has to go through much worse traffic or take a ferry or depending upon situations. So how do you add that into what you're looking at? All right, so we're going to go to the last one, I think, probably.
Probably. Mm-hmm.
Okay, let me flip to it real quick. Dr. Johnson's important information. Dr. Johnson has been retained by the family law attorney to consult concerning the court-ordered custody evaluation of his client, Miss Baggett, the mother in a contentious custody dispute. So Dr. Johnson here is a consultant. The mother, Mrs. Baggett, is seeking full legal and physical custody of the two children. After reviewing all the documents, Dr. Johnson meets with Ms. Baggett. In the course of Dr. Johnson's interview with Ms. Baggett, she relates information that leads him to believe that she has physically abused her elderly mother a number of times. It is clear that this abuse has never been reported or investigated. Dr. Johnson approaches the attorney and tells him of the statutory obligation to report this elder abuse. The attorney directs Dr. Johnson to not make such a report, stating that whatever reporting obligation psychologists might have in this situation, attorneys have no such reporting obligation in this state, and indicates that all that has been related is covered by the attorney-client privilege. What, if anything, should Dr. Johnson do?
Report?
Report. What are your thoughts on how do you end up with that decision? What are some of the factors that went into making that decision? You made it quickly, but you must have some thoughts on why.
There's a reasonable suspicion of an identified target. You have to make a report.
Okay, so that's one aspect, is do you have a reasonable suspicion? And it's not 100% clear from the vignette, but she's told you this. So unless you have some factor to believe that she would have a reason or a motivation or a personality that would lead her to tell you things that are completely untrue, she's reported it to you. Does that rise to reasonable suspicion in your state? What does your state say? Do you have an elder abuse? We're assuming an elder abuse reporting requirement.
But let's just ask the question for a moment. How would, if she reported to you that, and here's what it says, she relates information that leads him to believe that she has physically abused her elderly mother a number of times. What could possibly lead you not to have a reasonable suspicion? She could be psychotic. Right? She could be reporting something that happened many years ago and her elderly mother's now dead.
And in some states there's still a reporting requirement, and in others not. Statute. And actually I'll make a point on that. I know that's true with child abuse. It may not be true with elder abuse. But in Maryland, for example, if child abuse has occurred, it doesn't matter when it occurred. The child could be now an adult, but if you're hearing about the abuse, the statute would be read to say that you need to report it. So, so one thing you can do in many states, this is a little tidbit of advice, that when people call us and they're not sure whether it's reportable, one of the possible options is to call anonymously and say, here's a fact pattern. Would you say this rises to the level of reporting, and then document, your answer. But so if you report, how is that going to impact your relationship with the attorney and the attorney's situation? Doesn't matter to you. Has anybody thought about what informed consent you would want to have had going into this situation?
I think John.
Yeah, did you have a comment? It probably would end your relationship, certainly at least with this attorney, and probably in... And you might be even in a situation where you're looking at if there was not informed consent and it wasn't in any kind of contract, that you had these reporting requirements and that you would need to report if certain things came out, and that's not in your consulting agreement, and you've basically breached privilege of the client of the attorney, you could possibly be making a choice between a licensing board action for not reporting and a breach of contract action by the attorney. So what kinds of things do you want set up before you go into a consulting situation? And what informed consent? What do you think about the informed consent to the person you're interviewing in a forensic setting? Any thoughts on that? And you're going to say that to both the person you're interviewing and to the attorney as part of the... Is everybody in agreement on that?
So you would write it into your agreement with your attorney?
Not just say it to them.
Yeah, you would write it into your agreement.
That's California. Now, one thing that's interesting, we often get calls about duty to report or duty to warn, terrorist-off warnings. And is it ethical? What do I ethically need to do? Is it ethical to report? And one part of this is actually fairly simple, which is rare in ethics. So 4.05 says, and we mentioned it before, if you're mandated or permitted by law for a valid purpose, you can disclose confidential information without the consent of the individual if it's mandated by law for a valid purpose. And the child reporting statutes are one of those things that are seen clearly as mandated by law for a valid purpose. Now that's talking about the confidentiality piece, whereas before we were talking about the privilege piece, which is a statutory right of the client of the attorney. So that's kind of a little bit different, but I just wanted to point that out because occasionally we'll get a call and someone will say, well, I have this duty to report, but I'm worried about, what about confidentiality and what about ethics? Am I going to be held to have breached confidentiality? And the ethics code has that exception already in there because this occurs.
That's a good question.
It's an excellent question. One aspect of it is really more of a legal privilege question, and it's beyond my level of expertise on privilege, whether that would make some kind of difference. I'm not thinking it would, but I'm not 100% sure. But the other aspect of that goes to, reasonable suspicion. And what is it that he's told, and now you're hearing it secondhand, and, but that's, we will almost call it a clinical judgment. And, but it's sort of a judgment that you have to make about whether this rises to the level based on your state statutes level. Are the kinds of facts leading you to think that you should make a report? And it kind of depends on your state and the facts you hear and how you put it all together. Well, that part, I would say, no, they're not, because you are the consultant to the attorney, and all your work is attorney work product as the consultant in this situation. So that aspect, it's pretty clear that it covers that privilege. Whether it's stronger or not is what I thought you were asking, and I don't know the answer to that.
So how could you have avoided this whole thing? Retire.
Retire.
That's one way. Yeah, that's an option. Okay, so that's one really good option, that no matter what, we should always be doing that, right? What's another option? Sort of related to your point. Well, listen to what it says here. Dr. Johnson has been retained by a family law attorney to consult concerning the court-ordered custody evaluation of his client, Ms. Baggett, blah, blah, blah. The mother is seeking, blah, blah. All right. After reviewing all the documents, Dr. Johnson meets with Ms. Baggett. Yes.
So depending upon how you read the scenario, and I think it could be read more than one way, but one way of looking at this is they were hired to do the review of the child custody evaluation, and now they're starting to meet with people and getting additional information.
So I think that's a really good point. I find that if I were to see the client or someone else, who's doing this, sees the client, then on the witness stand, the other lawyer says, "And did you meet with Ms. Baggett?" It is, I think, much more effective, and you become a much more credible witness if you are able to say, "No, I met with no party to this evaluation." So I'm a strong proponent of never meeting the client.
Now it's interesting because this scenario could also be the scenario where, and this would be more clearly attorney work product, because as soon as you get on the stand, the privilege has been, you don't have there's not the privilege anymore. Right. You don't have the privilege anyway, but there's not the privilege anymore. This could be a scenario where Dr. Johnson is hired to help with formulating questions for the child custody evaluator. So he's really he's going to be working behind the scenes. He's not going to testify. He's reviewed the documents so that he knows the scenario, and he wants to meet with her for and it could be a valid purpose and it could be an invalid purpose. And that's a different scenario than the testifying expert.
Correct. That's a very good point.
So it's unclear. It's sort of, you know how vignettes are. We try and make them.
So, Lindsay, you say that the ethics office always says the greatest loss is the loss of your license. If you have to choose between a contract action by the attorney or a licensing board action, most psychologists would say that I'd rather fight the contract action. But recognizing, someone said, and I think they're gone, recognizing that, if you haven't set this up to start, you could be in a situation where really it's going to impact your business, and you're going to be in really between a rock and a hard place. And also the informed consent goes to the person you're interviewing as well. You can look at some of the sections. There's several sections on informed consent, and several of them talk. But one of them is 3.07, third-party requests for services, and it talks about clarification of the information, what the limits to confidentiality might be, things like that. And part of that would be your normal thing that you say to folks about child reporting and elder reporting, if you have elder reporting in your state. So, yeah, we can do a little bit more. Does anyone have any last thoughts about that one? Okay, we've got one more that is going to really just bring up a whole list of issues, which is
and we've got 15 minutes.
Yeah. So Danforth Williamson is a law firm specializing in family law in a large urban city in the U.S. It's considered one of the premier family law firms and an especially good choice for a divorcing spouse for whom a custody battle is likely. Danforth posts the following ad to its website: "Wanted, dead or alive. State licensed psychologist for part-time position as in-house trial consultant. Position will involve witness evaluation and preparation, case development, trial preparation, review of child custody evaluations, and short-term therapy. Experience in child custody, substance abuse, domestic violence, and treatment of anxiety and depression in adults preferred." Dr. Sarah Moore is a forensic child custody evaluator who has mentored many young psychologists throughout her career. She receives a call from Dr. Tim Lincoln, a psychologist whom she has mentored for several years, asking for a consultation. He has seen the ad and is very excited at the possibility of working at the law firm. Times have been tight recently due to the economy, and Tim feels this may be a golden opportunity to anchor his practice. Tim knows that Sarah has on occasion acted as a consultant to attorneys by reviewing the child custody evaluations of other psychologists. He would like to come in and discuss this opportunity to better prepare himself for the interview process. Sarah schedules a time with Tim and hangs up the phone. She suddenly finds herself feeling anxious. She begins to make a list of issues to discuss with Tim when he comes for the consultation. What should be on that list? Yeah. It's a peer consultation about, to help him think about this new job. Let me go back to the table of contents, too.
So how many people would be interested in interviewing for this position at the law firm? What are some of the concerns you would have with doing so?
Yeah, we have a couple firms in our jurisdiction who have hired psychologists. I don't know if the list of roles is as great as this, but...
So one aspect, though, if you talk about the short-term therapy, who has access to the information, what's going on in the therapy, it sounds like it could be anxiety and depression treatment. It's kind of unclear. So what are the issues that are going to come up in that therapy? Who's going to have access to those records? How is that going to work?
How is it paid for?
How is it paid for?
If you're on salary at the firm, what does it mean so let's say you're on salary. What does it mean in terms of how does that client get billed for the therapy services? If you're not on salary, but you have a hourly fee or whatever it is, what happens? What are the issues about fees in that case? That's the question, right? Who's paying it? And what does it mean if the firm is paying it? And what does that mean about, as you brought up, about records? How do you keep the records? Are they commingled? Exactly. Or they've got a client and they say, this one, you got to shine their sneaker a little bit. Can you please take care of that? And now, by the way, I want you to do some litigation support for this case.
For that same case. Mm-hmm.
So that brings us to what? Multiple relationships, right?
Mm-hmm.
3.05. Mm-hmm. Yes.
So that would be something that...
like an HR kind of...
EAP kind of
EAP,
thing.
yeah, that's it.
So that's something that if you were interviewing, you'd have to be delineating some of these issues, what you're going to do, what you're not going to do. What are they thinking in terms of short-term therapy? Is it the attorneys and the other staff in the firm? Is it the clients they have, but then are we going to be seeing those same clients to do other things for prep?
So can I just go back for a moment to fees? Because 6.07, referrals and fees. When psychologists receive payment from, or divide fees with another professional, other than in an employer-employee relationship, the payment to each is based on the services provided and not on the referral itself. So another clarification point about that.
We're not sure that there would be a referral. It probably wouldn't be a referral fee, but thinking through how is this fee structure going to work, and would it really work? Could you bill insurance? You have to really think through those how the money flows.
I don't see how you can ever be perceived as objective.
And say more about that. Why? Pardon?
You're a hired gun.
You're a way higher gun. You're working for a firm.
But how could you, I'm sorry.
At least in evaluations, you have to set up a reasonable arrangement for fee that maintains objectivity and neutrality. If you don't, they now cover half or some large percentage of your income.
But would it depend on what you're willing to do for them and what you're not willing to do? So does you're a hired gun if you're testifying, right? Yeah,
but you're behind the scenes.
But you're behind the scenes.
unless that's what they're wanting to do the rest of their life, I think it would be hard for you to ever be perceived as somebody who could perform a good evaluation or even
So you,
therapeutically about that as well.
yeah, it's interesting though, because you're basically thinking that once you've taken this job, it's tainting all other jobs with all other clients in any other setting. It could. And how could you limit that? What kinds of things would you want off the list and on the list? One aspect I'm trying to get at is, would you ever want to do this job and also try to testify regarding some of their clients? That's really what I was trying to get to. Because that's where you do want to be not perceived as much by the court as a hired gun. And if you're there testifying and you're an employee of the firm, you really do have that sense of a hired gun.
In some particular jurisdiction.
Mm-hmm.
So what do people think of that? If you pull someone's record, you might find that 60 or 80% of their income is coming from consultancy agreements. Mm-hmm. You think that's a problem?
Well, they wouldn't put you on the stand if you couldn't. If you said, you got a real doozer here, and there's not much I can say except such and such, unless the contract with them is no matter what your opinion, you're going to testify according to their wishes. In which case, you're doomed right away if you were to sign such a contract. But they wouldn't put you on the stand.
I mean, I'm totally feeling what you all are saying about trying to testify when you're the employee.
Yeah.
But I'm more thinking, I'm resonating a little bit with what you said. If you're talking about just doing behind the scenes consulting, how is it different being an employee versus being a consultant and saying, and helping with the prepping of the questions, or looking at the child custody evaluation and saying there are weaknesses here, here, and here. Here are the strengths you want to not focus. This is really good about what was happening. Are people seeing a real difference there?
Yeah.
Okay, so help me see why you think there's a difference.
Mm-hmm.
So some of that is making sure that you've really defined it up front. That you really are going to have a real strong list of what you can and cannot and will and won't do. But you think that will erode over time, is what you're saying. Mm-hmm.
It also says in here you're doing witness evaluation and prep. What problems could come up in that?
Telling them how to game a Rorschach or how to,
Well, you could be. Exactly. That's certainly one of the possibilities. And if you look at 9.11, we're also then concerned about test security.
Right. Psychologists make reasonable efforts to maintain the integrity and security of test materials and other assessment techniques. Consistent.
between that and client preparation.
Well, there is a line there, isn't there?
Where is the line? And that's where there's a huge controversy in the field. Some people think you can go this far. Some people think you can go this far. Some people say if you're preparing a witness such that it's going to change their behavior for the purposes of the evaluation only, that's not okay. Other people say it's fine. So there's a huge controversy about that. Mm-hmm. How many of you think that you could take this job and limit in a written agreement what you would do, the sort of bounds of what you could do? Hugely.
From what the ad says.
Yeah.
Mm-hmm.
I think our time is
Yeah, I think our time is up.
But you've been a great.
Thank you very much.
Thank you very much.